You want to step right up here to the podium, ma'am? If you would, please raise your right hand. You swear to translate from English to Portuguese and Portuguese to English the best of your ability?
I do. Vera Jefremovas, Portuguese interpreter.
Okay. Mr. Robson Lucas da Silva Fernandez, you're here this morning. You need to translate as I speak.
Oh, you want to do sabotage? Okay, Sr. Robson Lucas da Silva Fernandes, o senhor está aqui
For one count
por uma acusação
of touch, strike, battery, domestic violence.
tocar, violência doméstica, bater,
One count of assault, domestic violence.
uma acusação de agressão, violência doméstica
And two separate one case where it looks like he missed court,
e
and
caso no qual o senhor não compareceu ao tribunal.
there's a capias on that case on two separate
Tem
counts.
capias nesse caso, duas acusações separadas.
A capias is a warrant.
O capias no caso, tem uma cientificação.
And there's a bond of $500 on each count in that capias.
Ok? Tem uma fiança de $500 cada uma dessas acusações nesse capias.
And as to the one count of
Uma
touch, strike,
acusação de tocar,
battery, domestic violence,
bater, violência doméstica.
I find probable cause.
Eu determinei que existe causa provável.
And on the assault, domestic violence, I find
E na
probable cause.
agressão, violência doméstica, eu também julguei que existe causa provável.
Does the state wish to be heard?
O Estado gostaria de dizer algo.
Your Honor,
Vossa
I
Excelência,
don't see any history other than the
eu não vejo
battery
nenhum
charges he's facing on 3
antecedente
and 4.
além dessas acusações
Is that a
de
battery case as well?
agressão.
3
E
and 4
também
are
um
2
caso
counts
de
of battery.
agressão. 3 e
Is it
4
the
são
same
2
victim?
casos de agressão, é a mesma vítima.
It doesn't appear to be domestic in nature.
Não parece ser de natureza doméstica.
Obviously, Your Honor is familiar with the probable
Obviamente, a
cause
Vossa
affidavit.
Excelência conhece o affidavit de causa provável.
And I would just ask the court to setting a bond to take into consideration the threat to kill.
E então a corte só pediu uma fiança
And that the alleged victim felt it necessary to grab her 1-month-old daughter and climb out the window for help.
e essa vítima achou que era necessário que ela pegasse a filha dela de 1 mês e pulasse a janela para pedir ajuda.
Defense, you wish to be heard?
A defesa gostaria de dizer algo?
I'm speaking, Mr. Fernandez. He's been
You need to translate that too.
O senhor,
12 years.
o senhor Fernandes está residindo no mesmo local já fazem 12 anos.
He's 36 years old.
Ele tem 36 anos de idade
He's currently employed. He works in construction.
e ele atualmente está trabalhando e trabalha em construção.
He makes approximately $350 per week.
Ele faz aproximadamente $350 por semana.
At this time, financially, he says he has no money in the bank, owns no property.
Nesse momento, ele diz que ele não tem nenhum dinheiro no banco e também não é dono de nenhuma propriedade.
The alleged victim is his wife.
A vítima alegada é a sua esposa.
He'll be living separate and apart from her. He'll be residing with his brother.
Ele vai morar separadamente dela. Ele vai morar com o irmão dele.
Does the state have any contact with
Resides
the?
in Pompano Beach.
Sorry.
His brother resides in Pompano
O
Beach.
irmão dele mora em Pompano Beach.
I'd ask you to take into account his financial resources in determining a reasonable bond judge.
Ok? Então, eu levei em consideração os recursos dele, Vossa Excelência, para determinar uma fiança razoável.
Does the state have any contact with this victim,
O
alleged
Estado
victim?
tem algum contato com essa vítima alegada?
We've not had any contact as of yet, Your Honor.
Não, ainda não tivemos nenhum contato, Vossa Excelência.
Okay, I find probable cause, as
Okay.
I said,
Eu julgo que existe causa provável, como eu mencionei,
on count 1,
na acusação de número 1.
set bond in the amount of $2,500,
Ok? A fiança é no valor de $2.500.
and on count 2,
E na acusação 2,
set bond in the amount of $2,500.
a fiança também vai ser determinada no valor de $2.500.
No contact
Nenhum contato
with
com
Flavia
Flávia
Germana
Germana
Suarez
Soares
Ferreira.
Ferreira.
You understand that?
Você entende isso?
Yeah, sim.
Yes.
Okay, thank you.
Obrigada.
Thank you.
Did
Appreciate
I
it.
offer the interpreter, Your Honor?
Thank you very much.
Thank you, Your Honor.
Anique Cogan Austin.
North Broward, Judge.
Anique Cogan Austin. Good afternoon, Ms. Austin. You're charged with one count of battery causing bodily harm. It looks like bond has been set in the amount of $1,000. I do find probable cause.
Judge, Miss Austin has lived here all of her life. She has extensive family here. She has enough money to bond herself out, but unfortunately, the money is at her house. No one yet knows that she has been arrested. She can't give me any phone numbers because all the numbers are in her phone, and her phone is not in her property. So I would ask the court to consider, I don't know what her prior criminal history is like, but I'd ask the court to consider pretrial release to let her get out of jail.
State.
Actually, Your Honor, I would just note, it actually looks like she's undercharged. The officer writes in his narrative that she committed an aggravated battery, striking the victim with a rock. I would also note her criminal history. It appears Miss Austin is currently out right now on a leaving the scene of an accident in the DWLS. 2015, grand theft auto, felony criminal mischief, 29 months state prison. 2014, grand theft auto, 29 months state prison. 2013, felony battery due to priors and criminal mischief, 29 months state prison. 2013, aggravated fleeing and eluding, DUI, 29 months state prison. 2011, 2 counts of aggravated battery. She was sentenced to, looks like, a year and a day state prison. She was classified as a habitual offender. 2011, grand theft auto with a VOP. Disorderly conduct, 09, grand theft auto, 08.
Ms. Austin, your bond's set in the amount of $1,000. I do find probable cause.
Your Honor, we just asked for an order of no victim contact.
No contact. You shall have no contact with the alleged victim in this case. Ms. Nikitris Walden, you understand that? Yes, ma'am. Okay. Mae Francis Colson.
I've been advised she's bonded.
Bonded, I find probable cause. Inoa Matelas.
I've been advised she's bonded, Judge.
Find probable cause, bonded. Gloria Tillman.
She's in North Broward, Judge.
North Broward?
Yes, ma'am.
Give me a second. In a wheelchair. Hold on.
Ms. Tillman. Yes. Charged with one count of burglary with assault or battery, one count of resisting an officer with violence, one count of resisting an officer without violence. Don't say anything about your case, okay, ma'am? State.
Your Honor, the state is seeking a no bond hold on count 1, the punishable by life offense. Your Honor, the state would be arguing for first appearance purposes only that the burden of proof evident or presumption great has been satisfied by these
Don't
allegations.
say anything about your case, Ms. Tillman.
It's okay. Pursuant to Brackett and Isaza, both out of the 4th ECA, which also the 4th finds that the state can rely on only a probable cause affidavit in satisfying proof evident or presumption great at a bond hearing. Your Honor, noting that the allegations provided by the alleged victim, and he also provided a sworn statement, would satisfy the elements of a burglary with assault or battery, noting that Ms. Tillman was still in the residence when law enforcement arrived, And even if the court was not satisfied with the allegation,
Miss Tillman, can you hear me? Can you hear me? Miss Tillman,
Ms.
can you hear
Tillman.
me?
The judge is talking to you, Ms. Tillman.
Can you hear me? Okay, Miss Tillman.
And that man lied, and I'm calling it on the feds. I'm calling. My mom never gonna get on it right now.
Okay. Ms. Tillman, I do find probable cause for a burglary with an assault or battery. Pursuant to the case law, I do find that the proof is evident, the presumption great, and on count one there'll be no bond. You can see the judge. You can see the judge whose case it is.
Our position, Your Honor, that the court has in fact conducted an Arthur hearing by making that finding, not to preclude Ms. Tillman from seeking a further Arthur hearing in front of her division judge. But our position is that proof evident presumption great is a very high legal standard, higher even than proof beyond and to the exclusion of every reasonable doubt. Our position is the state has not met that burden just by introducing or showing the court a probable cause affidavit that is designed to establish probable cause, certainly not designed to establish proof evident presumption great. The state has not called any witnesses. They've produced no evidence. They've alluded to a statement made by the victim, which we have not heard and have not seen a transcript of. So I would argue that proof evident presumption great has not been made. In addition to that, even if the court does make that finding, the court can still, in its own discretion, set bond, and we would ask the court to set bond for Ms. Tillman in this case.
Okay, Mr. Reedy, I do find, as I said, based on the probable cause affidavit, that I do find probable cause. I also find that the proof is evident, presumption great. I'm going to hold her on no bond on count one. On count two, there's no bond necessary. On count two, I'll set bond in the amount of $1,000. And on count three, there's a $100 bond. She's free to seek a bond hearing with the judge who her case is assigned to.
Very well, Judge.
Thank you.
Your Honor, just
Thank you,
in,
Mr.
I'm sorry, just in the abundance of caution, I just asked for no victim contact.
No victim contact in that case as well. Maria Edwards. Pardon me?
She's here at Miami, and she declined the services of public defender, Judge.
Okay. Miss Edwards, you're here today charged with battery on an officer, firefighter, EMT, and I have read the probable cause affidavit. I do find probable cause. State, do you wish to be heard?
No, Your Honor.
Defense?
Yes, Judge, if I could have 1 moment to speak to her. She did initially decline, but she's changed her mind. She wishes to apply for the public defender. I just need 30 seconds to talk to her.
Okay.
Thank you. Thank you for giving me that opportunity, Judge. And speaking of Ms. Edwards, if the state can verify, my understanding is this is her first arrest ever. She's been residing in our community for over 13 years. She is employed. She just obtained a job working at Ross. She's making $9 an hour. She is a single mother. She has a 1-year-old child. She lives with her uncle. Judge, considering Ms. Edwards' first contact with the criminal justice system, her strong ties to the community, we do understand this is a felony charge, but since she has no priors, and I did see that in reading the probable cause affidavit, the alleged battery was a push. I don't mean to undermine, but I've seen more egregious probable cause affidavits. I would ask you at this time to consider a $500 bond on Ms. Edwards' behalf.
Is Miss Edwards residing with Luis Daniel Guzman Martinez?
Let me inquire. Judge, I believe sometimes she spends the night with Mr. Martinez at his apartment, but her permanent address is in Fort Lauderdale, residing with her uncle and family members.
Okay. State, do you wish to be heard?
Your Honor, the only thing when setting a bond, I'd ask the court to take into consideration, as mentioned in both her probable cause affidavit and his co-defendants, this allegedly occurred while a child protective investigator was just trying to do her job in investigating some issue with regards to a child.
Do you know anything about that?
I don't know anything about the underlying details, unfortunately, Your Honor.
Do you know anything about the status of the officer who was transported to the hospital?
I don't know. I mean, it mentions swelling and bruising. It does, I mean, yeah,
You don't have any other information?
no, I don't know anything other than what's in the report, Your Honor.
Okay, I do find probable cause. I'm going to set bond in the amount of $2,500. No contact with the co-defendant in this case. Louis Daniel Guzman Martinez.
Yes, Judge.
Okay.
Sergio Luis Salome.
Judge, she's going to be requiring a Spanish interpreter.
Okay. We'll put it on recall. Devin Anthony Gonzalez.
I've been advised he bonded.
I do find probable cause. Oops. James Bubello.
Mr. Bubello is here present, Judge, on Maine.
Mr. Rubello, you're here today. One count of burglary of an unoccupied dwelling unarmed, one count of grand theft, one count of burglary of an unoccupied dwelling unarmed, dealing in stolen property, and grand theft. Looks like these cases were direct filed.
If you'd like, Your Honor, I can advise you what he's being held on his other charges.
Okay, I have read the juvenile probable cause affidavit as to these cases. What else does he have?
Count one's a robbery firearm. He's got no bond hold on that. Count two, grand theft auto, $1,000 bond. Count three, grand theft, $1,000 bond. Count four, resisting without violence, $100 bond.
Yeah, I do find probable cause on count 5, burglary of an unoccupied dwelling, bond in the amount of $1,000. Grand theft, $300 to $5,000. Count 6 is $1,000 bond. Count 7, burglary, unoccupied dwelling, $1,000 bond. Count 8 is a $3,500 bond, and count 9 is a $1,000 bond. I do find probable cause as to all counts. If Mr. Bubello is able to bond out, he's to have no contact with any of the co-defendants in these cases. Myron Tavares Jones.
Mr. Jones is here present, Judge, on Maine.
Mr. Jones, you're here this afternoon on one capias on a criminal traffic case with Judge Brown where you missed court. There's a $500 bond set on that. You're also here on a violation of probation. There's no bond on Judge Merrigan's case. You need to see Judge Merrigan. Looks like there's a status with Judge Brown on June the 8th at 10 o'clock in the morning. Looks like there's a scheduled hearing with Judge Merrigan on June the 1st at 8:45. I do find probable cause. Jeremy Douglas Gray.
Can you let the judge know I never received a court date?
Judge, she says he never received the court date.
Yeah, I never received a court date, and this is like tampering with my job as well. But
Okay, well, you need to see Judge Merrigan anyway on a violation of probation, so.
Bob,
Jeremy Douglas Gray.
Mr. Mr. Grace here, present, Judge.
Mr. Gray, you're here on a possession of cannabis, 20 grams or less. The bond is set in the amount of $100. You're also here on an out-of-county hold from Dade County. There's a no bond hold from Dade County. You'll need to see the judge in Dade County. If you'd like to resolve the possession of cannabis today, I'd be willing to withhold adjudication, impose $293 in court costs. Give him 6 months to pay that.
Let the judge know if you want, if you wish to accept your offer. Yes, ma'am, I'd like to accept that.
Okay, is the public defender office representing him?
No, Judge.
Okay. Mr. Gray, raise your right hand. You swear or affirm to tell me the truth?
Yes, ma'am.
You can put your hand down. State your full legal name for me.
Jeremy Douglas Gray.
Mr. Gray, you're here this afternoon on one count of possession of cannabis. It's a misdemeanor charge. It's punishable by up to 1 year in the Broward County Jail. You understand that?
Yes, ma'am.
If you'd like to resolve the case today, if you want to enter a plea of guilty or no contest, I'll withhold adjudication, impose $293 in court costs. You'll be held no bond on your case in Dade County until they come pick you up. You understand?
Yes, ma'am.
Anybody threatening you or coercing you or to do this? Are you doing this because you believe it's in your best interest?
Yes.
You understand you have an absolute right to have a trial if you'd like.
Yes.
Would you like to give up that right to a trial and enter a plea of no contest or guilty today?
Yes.
Okay, then I'm going to ask you, you're alleged to have had a misdemeanor amount of cannabis in your possession when you were arrested by the officer on the warrant from Dade County. Is that accurate?
Yes.
Okay, how would you like to plead, guilty or no contest?
Guilty.
Okay, Mr. Gray, I'll accept your plea of guilty. I'll withhold adjudication of guilt, impose $293 in court costs, and I'll give you 6 months to pay that, okay?
Thank you.
Christopher Sergio Dennis.
Judge, he declined to serve as public defense.
Okay, Mr. Dennis, you're here charged with driving while license suspended as a habitual offender. Your bond is set in the amount of $750. I do. Pardon? Your bond has been posted, apparently. I do find probable cause. Jason Van Dykes.
Mr. Dykes is here present, Judge. He declined to serve as public defender. He advised he has private counsel, Mr. Ben Nichols.
Good afternoon, Judge.
Bob Nichols.
How are you?
How are you?
Excellent, thank you.
Mr. Nichols is present. Can you see him, Mr. Dykes?
Yes, ma'am.
Okay. Mr. Dykes, you're here this afternoon charged with one count of driving under the influence, another count of driving under the influence, both by accompanied minors in the vehicle, counts 3 and 4, child neglect without great bodily harm, and count 5, possession of a controlled substance without a prescription. I do find probable cause. I have reviewed the probable cause affidavit. State, do you have any position with regard to the bond in this matter?
Judge, I do have a question about the probable cause.
Okay, well, let's hear from the state first with regard to
Sure.
your suggestion as to bond.
Your Honor, it's just going to be asking for $1,500 per count on 3 and 4.
Okay. Okay, defense?
Judge, I noticed that there's nothing in the PC regarding the ages of the children. There's a vague reference that the wife showed up to claim her children. I refer to my children as children even though they're out of college. So there's nothing to indicate that there was a juvenile in the car. There's no real witness here other than a vague reference that the officer spoke with another gentleman who was not present. He's not named. Gives very little as to what the gentleman saw. So I think they have a real witness problem. The person that did speak with the officer only said that spoke of the defendant. He didn't say anything about the children being behind the wheel. So there is no PC, respectfully, regarding the aggravation of having the child in the car. In addition, Judge, DUI with child neglect, I believe with the DUI with the child inside and the child neglect would be a double jeopardy situation. They both refer to the exact same act. I don't think they would make it through a Blockburger. I haven't checked that with the specific case law, but it seems to me that they both relate to the same exact factual scenario. The pill in his pocket, Judge, was he suffers from migraine headaches, and that is a pill, that is medicine which is routinely used. I don't know if he had a prescription for it, but I do know that there was a reason other than just having a recreational drug. So, Judge, given the fact that it's really one DUI, and I understand under the quirks of Florida law that you can do multiple DUIs for a single issue, ultimately, as you know, they're usually resolved under a single DUI. I would ask that that a single bond be issued, or the equivalent of a single bond be issued on this, and that no probable cause be found regarding the issue of the children.
State.
All right. First, start with the easiest. As far as double jeopardy, it can't be double jeopardy. Jeopardy hasn't attached yet. Secondly, it's two DUIs. One is for the breath, and one is for the children being present. There is a witness after the crash that saw Mr. Van Dyke leaving the vehicle and the two children, Your Honor. And it would appear that the children, and I would note they're referred to as young children, were released to the mother, medically cleared and released to the mother. I don't believe they would have to do that, and I don't believe that is an issue with any person over the age of 18. They don't have to be released to anyone.
I do find probable cause with regard to the issue of bond. Mr. Nichols, I'll hear from you on that.
Judge, he was born.
Right now, there's currently set on count 1 $1,000, on count 2 $1,000, and on count 5 $1,000. It leaves me to set counts 3 and 4.
Judge, I realize jeopardy hasn't attached because he hasn't been formally charged yet, but in effect, jeopardy is attaching now with respect to the bond. This is all the same activity. I believe that $3,000 already doubles up on the DUIs. To go beyond $3,000, respectfully, I think would be excessive.
Does he have any priors?
See, in 2003, he went through drug court for possession of alprazolam.
It was dismissed in drug court.
Does pretrial have anything? Thank you.
You showed nothing?
Nothing further than what the state already.
Okay, on count 3 and 4, I'm going to release him on his own recognizance. I'm going to leave the other bonds as they stand, which is $3,000. I'm also going to order that he be on pretrial release, that he call in 3 times a week, and that he have an alcohol evaluation within 7 days of his release. I do find probable cause as to all counts.
Very good.
Submit to any recommended follow-up treatment.
Yes.
And, Your Honor,
How often does the court want him to be tested?
Random testing is fine. That's up to pretrial.
state
Thank you,
would
Mr. Nichols. Nice to see you.
well, Your Honor, the state would be requesting an order of no contact with the children based on the child neglect charges.
I'm not going to order that at this time.
Thank you, Judge.
David Paul Kaliba. Mr. Kaliba, you're here charged with petty theft. You're also charged with trafficking in amphetamine, 14 grams or and less than 26 grams. Bond in that case is set at $50,000. Drug paraphernalia, driving where your license is suspended. Also here on a violation of probation or community control on 1, 2, 3, 4 separate cases with Judge Tobin Singer. I do find probable cause, and you will see Judge Tobin Singer on June the 5th at 9 o'clock.
Judge, and it's being Mr. Koloba, he wants me to address with Your Honor in reference to count 2, the $50,000 bond. Unfortunately, at this time, he's unemployed. He's been currently looking for employment. He hasn't had any sort of success finding employment. He lives here in Fort Lauderdale. He's been staying with a friend of his for about a year and a half now. Unfortunately, due to his financial situation, he can't even afford his share of the rent, so his friend has been helping him as far as covering his cost of the rent. However, he doesn't believe that his friend or anyone in the outset could potentially post this $50,000 bond. Considering his lack of financial resources, he's requesting, Judge, if you consider reducing the bond from $50,000 to $10,000 on count 2.
Considering that he has 4 pending cases that he's being supervised on, I'll respectfully deny that motion.
Yes, Judge.
Fred Grant Bruce.
Mr. Bruce is here at Main, Judge. He's approaching.
Mr. Bruce, you're charged with DUI, alcohol or drugs, 4th or subsequent offense, DUI with damage to property or person of another, thank you, refuse to submit to a DUI test, leaving the scene of a crash involving damage to property, failure to provide proof of liability security, failure to use due care, expired motor vehicle registration over 6 months, and there's a capias in a warrant that was issued on a 2017 criminal traffic case where there's a bond in the amount of $100. As to
Your
count,
Honor?
yes.
So I just want to advise the court before you set bonds that it appears Mr. Bruce is also out on release on grand theft.
Yes, with Judge Rothschild. So on case number 160000784, I'm going to revoke his bond on that case.
I'll prepare an order for the court.
Judge, in reference to...
Hang on, let me make a finding of probable cause as to all of the other counts.
Yes, Judge.
On count 1, I'm going to set bond in the amount of $5,000. On count 2, there's a bond set of $1,000, and on the capias, there's a $100 bond. If Mr. Bruce is released on this case, on the $5,000 bond, he'll be on pretrial release with a TAD monitor. Yes, sir.
Judge, my understanding is being Mr. Bruce, what we're asking you is to reconsider holding Mr. Bruce no bond on the case that he's currently out on bond on. My understanding is he's been out almost close to 2 years. Basically, holding no bond is the most severe sanction magistrate court could impose on Mr. Bruce at this time. I'd ask you to consider at this time a less restrictive alternative, potentially placing him on pretrial with the TAD monitor, level 2, so that would allow him to continue working. He currently works in construction. He's been working for the same company for the past 20 years. By him being held on, that would be jeopardizing his employment. Judge, I'd ask you to reconsider the no bond hold and place him on pretrial release level 2.
State.
Well, Your Honor, as far as what, if any, bond is set, I do believe Mr. Bruce is a danger to the community. While out on a felony case, he's getting into an accident in what would appear, the court has found probable cause for his 4th DUI. He also has priors for aggravated fleeing and eluding, another grand theft in 07, battery on a law enforcement officer, misdemeanor battery. I believe it would be appropriate for Judge Rothschild to decide if what if bond, if any, is appropriate.
He has a public defender on the case 160000784 CF10 with Judge Rothschild. So I'm going to revoke the bond today, and his attorney can see Judge Rothschild on that case.
Yes, Judge. Would you sign a photo order?
It's count 1, 2, 3, and 4.
Right, 3 and 4 has no bond attachment. We're gonna put them all on trial with a tab line.
Right, but count 1, I set a bond in the amount of 5,000. Yes. Thank you. Robin Voorhees.
Mr. Voorhees is here present, Judge. He has private counsel, Mr. Jim Lewis.
Okay, Mr. Voorhees, don't say anything about your case, okay? You're here today on, looks like, failure to wear a seatbelt. You're also here on a violation of community control. Looks like you need to see Judge Cohen. You'll see him on June the 5th at 9:45. I do find probable cause. Do you want to help us out here? We have the interpreter here
Yes, Judge.
on Sergio Luis Salome.
Salome?
Salome?
Oh. Salome. He's approaching, Judge.
Sergio Luis Salome.
Sergio Luis Salome?
Good afternoon, sir.
Buenas tardes, caballero.
Can you raise your right hand, sir? Do you swear or affirm to translate from English to Spanish and Spanish to English to the best of your ability?
I do, Your Honor. Martin Vido, court interpreters.
Mr. Salome, you're charged here today with a capias or a warrant,
Señor Salome, se le acusa hoy de tener una orden de arresto pendiente.
and that is for Judge Hurley, a $1,000 bond. I find probable cause.
Esto es frente al juez Hurley, $1,000 de fianza y fallo de que hay fundamento de hechos.
$1,000 bond, sir.
$1,000 de fianza, señor.
Okay.
Thank you. Does anybody else need an interpreter that you know of?
Espanol? No one else here at Maine requires an interpreter.
Thank you very much. Thank you for coming.
Thank you,
Appreciate
Your
it.
Honor. Have a good afternoon.
Aaron Terrell Moses.
Mr. Moses is approaching, Judge. He declined the services of public defender.
Mr. Moses, you're here this afternoon on aggravated battery on a pregnant female, someone you knew or should have known was pregnant. I do find probable cause on your case. The state wants to be heard.
Your Honor, if I could just, I was going to inquire pre-trial. He's, I don't believe he has any Broward priors. Do you?
Trying to determine if he has priors out of the county.
Yes, Judge. Moses, please.
You had any contact with the victim in this case?
No, Judge.
Subsequently, that charge was dismissed. 2007, possession of marijuana. He went for a diversion. 2013, possession of narcotic equipment and possession of marijuana.
And are those in Tampa?
Yes, Your Honor, beyond County.
Okay. I do find probable cause. State, you wish to be heard on the bond?
Your Honor, I'll leave in the court's discretion, just also noting it does appear that Mr. Moses has limited ties to South Florida.
Mr. Moses, is your address correct at 17102 Downs Drive, Odessa, Florida?
Yes.
Is that your correct address?
Yes, ma'am.
Okay. I'm going to set bond in the amount of $3,500. I'm going to order that you have no contact, direct or indirect, with Janelle Lynn until further order of the court. You understand that?
Yes, ma'am.
Okay. $3,500 bond. George Orlando Mullings.
North Royal, Your Honor. How you doing, Your Honor?
Mr. Mullings, how are you? Here today, this afternoon, you're charged with aggravated battery with a deadly weapon, aggravated assault with a deadly weapon without intent to kill, felony battery, and aggravated battery with a deadly weapon. I do find probable cause as to each count. The state wish to be heard.
Your Honor, just noting from what I can see, Mr. Mulling's criminal history, a couple DWSs, a possession of marijuana in 09, a battery in 08 that was dropped. Just based on the level of violence, Your Honor, I would be asking for $5,000 per count, no victim contact.
As far as probable cause is concerned, Judge, it does seem to me as though there are 4 charges, but it all seems like it's one event. One argument or fight or whatever happened between these two gentlemen. So it's not like there's an aggravated
Mr. Mullings,
assault.
you have an attorney here in the courtroom, so don't say anything about your case, okay?
So it would seem to me, Judge, that the court should take that into consideration when setting bond. It's not like there was an incident and then it stopped and then something else was reinitiated at some point in the future. He's got 2 charges of aggravated battery with a deadly weapon, and I think it should really be 1.
Okay, I do find probable cause as to each count. However, I do note what Mr. Reedy says with regard to the fact that it is one incident involving one victim, and so I will set bond on count 1 in the amount of $5,000. On count 2, set bond in the amount of $2,500, and on counts 3 and 4, bond in the amount of $1,000. No contact with Romaine Orisma. You understand that, Mr. Mullings?
Yes, ma'am.
Okay. $9,500 is the bond.
Second. I didn't put him on my list for some reason.
Christopher Manuel Lopez.
I'm being advised Mr. Lopez bonded, Judge.
Sure. You let me know when, okay?
Any priors on Verona?
Yes, his bond was posted.
Okay.
Sorry?
That's on Christopher Manuel Lopez, right?
See if juvenile-
Okay, I do find probable cause, and Mr. Lopez has bonded.
I'm doing fine. For
Substantial.
some reason, you didn't make the list of people for me to talk to.
Louis Daniel
I see
Guzman
you're in a wheelchair.
Martinez.
You okay?
Mr. Guzman Martinez is here present, Judge, in Maine.
Okay. Okay.
Mr. Guzman Martinez, you're here today charged with a battery on an officer, firefighter,
sure you're getting medical
EMT,
attention,
and
okay?
1 count of battery
You
on
have
a
any mental health
DCF
issues I should be aware
employee
of?
or protective
Is there anybody I can call to
investigator.
help bond you out?
I do find probable cause as to each of those counts. On count 1, does he have any priors, Mr. Guzman Martinez?
I'm not showing any
it
Broward
3,
priors, Your Honor.
Okay, on count 1, I'm going to set bond in the amount of $1,500. On count 2, bond is set in the
she's gonna
amount of
be able to get that bond.
$1,000. The total bond is $2,500. Mr. Guzman Martinez, you're to have no contact with
5, 6,
Maria
7,
Edwards. You understand?
$950.
No contact.
Yeah.
Judge, would you sign a photo order allowing us to photograph Mr. Guzman?
Okay. I'll call her right after court.
Sure.
Thank you, Judge. Oh, I'm sorry.
Daniel Verona.
Mr. Verona, come on up, please.
Did Hanker just ask for a photo order on that guy?
Mr. Verona, you're charged with 1 count of burglary of an unoccupied structure, unarmed, 1 count of grand theft auto, 1 count of resisting an officer without violence, and 1 count of leaving the scene of a crash involving damage. I find probable cause as to count 1, 3, and 4. I find no probable cause as to count 2, grand theft auto. Anyone remember what bond I set on the co-defendants this morning on this case?
No.
Shaham White.
I can check that. That's fine.
Yeah, I don't remember.
I do have my morning notes with me. I can look it up if someone can tell me the page on it.
I've got it. Sorry.
Shaham White. I'm not sure of the page. I don't have it down.
WHYTE. Sir.
Mr.
You
Verona,
said
don't
the-
say anything about your case. You have an attorney right there helping you, okay?
You set the Berg structures at 2,500. Right?
Oh, yeah. Okay.
2,500?
That is correct, Judge.
Okay.
2,500.
So as I said, I find probable cause on counts 1, 3, and 4. No probable cause as to count 2. I set bond on count 1 in the amount of $2,500.
Thank you, Judge. So count 2 will be an ROR?
Yes.
Thank you, Judge.
Is that it?
Well, Your Honor, we're on our second dockets, but there's a matter I'd like to address before
Okay.
we get through.
So is that the,
That's the regular document, correct?
right.
Your Honor, I'm going to be asking that all the felony cases be reset for tomorrow. The procedure, as far as notice in this division, as long as I've been in this division, has always been that the Public Defender's Office emails me the afternoon before the list of cases that they're putting on the motion to release docket. On these 16 cases, I did not get any email on Friday. I got an email from the Public Defender's Office this morning. I've not had the agreed upon amount of time of notice to give notice to the case filers to look up their cases and prepare for the hearing. So in light of that, Your Honor, I'm going to ask that all these cases are reset for tomorrow.
Okay, just answer this question for
Sure.
me if you could,
Yes.
either of you. Why are these not set in the division where the judge is assigned the
It's
case?
pursuant to the administrative order when this division became a full-time division, Your Honor, years ago, that motions to release were to be heard through this division. At least motions to release that are going to be set by the Public Defender's Office.
Okay, but now that it's not a full-time division,
Well, it is still considered, and Your Honor, I can tell you, we brought this up with Judge Pohl,
okay,
and we found that normally the notice that I receive from the Public Defender's Office, it really streamlines it and makes it a lot easier
okay.
for both sides to deal with.
So you want me to hear these tomorrow?
I would ask that, Judge, just since I only got notice of them this morning.
Okay, so let's do them tomorrow afternoon at 1:30.
Judge, I'd ask you to hear the 30-day motions on all narcotics-related cases today. The state never gets these things filed in 30 days.
Well, I
These people
understand,
are just
but
going to be sitting another day in jail. We know they're not going to get filed between now and tomorrow.
at least Mr. Linder should have an opportunity to speak to the case filer so that he could report to me the status of the case so that I can make some intelligent decision based on what the status of the case is. So,
I'm lodging my objection, Judge. I understand what you're saying.
and I'll set it for tomorrow at 1:30. And I'll give these back to you, right, for those to be ready for
And
tomorrow.
Your Honor, just to let you know, I won't be here, but I've already been in communication with the ASA covering for me. They're aware of everything, and they will be able to advise the court
I
on.
see everybody's leaving on my week, huh?
Judge,
tomorrow.
that means we're done here at Maine, okay?
Okay.
Yeah, we just have.
Is there another gentleman there?
He was on the list of the.
There's one misdemeanor case, Christopher Dubois.
I
He's
see.
still
I
in
have one
custody.
case that says second look.
Yeah, that's Christopher Dubois. If he's still in custody, I'm checking to see what jail he's at.
Okay.
I got him here in North Broward.
North Broward. Okay. So what's the situation with this case?
Your Honor, it's a second look.
Okay. And is this a second look from last week or?
He was arrested, it looks like, on May 23rd.
Okay. May 23rd. And bond was set in the amount of?
The convenience bonds were kept in place. He got a $500 bond on the DUI, $1,000 bond on the DUI with a breath above a .15, and a $1,000 bond on the property damage. And, Your Honor, I can tell you, I actually asked for a bond increase. his breath results were a .332, .333.
I remember this PC sheet, yeah.
In light of his breath results, Your Honor, I think that's a 2,500 total is a pretty reasonable bond.
You know, unfortunately, I don't even have the probable cause
I can print
affidavit.
that out for you, Judge.
Well, I mean, I'd like to be able to at least give it a second look if that's
Sure,
what I'm
yeah,
supposed
no,
to do.
absolutely. I'll print that out for you right now.
All right.
Which bond can you afford, sir?
If I go through the bondsman, the $250.
Kiefer. Gotta stop putting stuff on the printer. Yeah, but the printer's gonna end up breaking.
Well, he just indicated he could make the bond.
Is that what you're telling us? Can you make a $2,500 bond?
No, sir. If I go through the bondsman, it's only $250, which I can't afford.
Okay. Can you get a hold of a bondsman from the jail?
I believe I can, sir, yes.
Have you made any efforts to try and bond out?
Not yet. I've been waiting to speak to the public defender.
All right.
You're
You're
speaking
speaking to one now. What can I do for you?
You just make sure you're aware that you're on the record, sir.
We're on the record, so we're not going to talk any
Don't
confidential
talk about the
stuff.
facts of your case. You want to talk to Mr. Reedy about how he might be able to help you bond out on this $2,500 bond.
Is there somebody I can call for you?
Well, yeah, you can call a bondsman because I really
That I
don't
can't
know.
do. That I can't do.
Well, they wouldn't let me bring my reading glasses for some reason or another, and I cannot see to read any notices, but there are people here that can help me contact a bondsman.
Okay. Because I can't do that for you. That's one thing I can't do.
Okay, understood.
All right, so you okay with a $2,500 bond then?
If I can do the $250 through a bondsman, yes.
You should be able to.
Absolutely.
Okay.
Okay.
I've read the probable cause. Mr. Is it, how do you say it, Dubois?
Dubois, depends on where you're from.
Okay, Dubois. Your bond is set in $2,500, okay? So, as you indicated, you get in touch with somebody and they can help you bond out, okay?
Sure.
All right.
And then what? I mean,
You're gonna have to. You're gonna have to come. You're gonna have to appear in court. Do you have an address where we could send you a notice?
No, I don't. I'm homeless, unfortunately.
Well, then it's going to be up to you to be looking, find out when your court date is. There's an address listed on your probable cause affidavit in Funston Street. Is that an address of somebody you know?
No, ma'am. That was my old address in Hollywood.
Do you have an address of somebody that would get your mail for you?
The only one I know is my mom, and that her address, I believe, is, if you got a pen?
Yes.
7007 Northwest 95th Street, 95th Avenue in Tamarack. 33321.
All right.
And please Google that to make sure it's accurate.
I'm not going to Google it. I'm going to change the address for the clerk of court so that they send mail to 7007 Northwest 95th Avenue in Tamarack, 33321. If you bond out, sir, it's your responsibility to make sure you get to court. Failure to get to court will result in a capias or a warrant being issued for your arrest. You understand that?
Oh, yeah, the bench warrant I do not want.
Okay.
You
So
can
good
check
luck.
online too, sir.
Which website?
Is it Broward Clerks?
Yes.
Okay.
Yeah, you can track it online, but make sure you don't miss court.
Okay.
All right, good luck.
Good luck, sir.
Thank you. Y'all be blessed.
Okay. Do I need to write anything on the paperwork for the second look one? And this other page. On this.
Okay, here. How long are you hanging out?
Right here.
I don't know.